This conference will now be recorded.
Maybe we'll wait just another minute or so and let people get logged in. Well, let's see. I'm sure other people will continue to file in, but maybe it would be good in respect of everybody's time to get started. Welcome back, everyone. Before we sort of jump into the business of this and then call the roll, I want to turn the floor over to Matt to say some introductory words. Matt?
Adam, thank you very much. I know this is your fourth meeting. Maybe this is more than you signed up for, but in any event, I'm confident that you will get this done today, or the committee will get this done today, and I thank you and the others. With that, let me turn it back to you to get started.
Thanks, Matt. Todd, why don't you go ahead and call the roll?
Yep, we have a lot of people joining, so I'm just going to do this very quickly. I see Adam White, the committee chair, is here. Jennifer Jones, alternate for James Anderson. Please say here once I say your name.
Here.
Emily Bremer.
Here.
Dan Cohen. Alana Cohen. Peter Constantine.
Here, good morning, thank you.
Great. Andrew Emery.
Here.
Emily Hammond. Richard Hippolyte.
Here.
Randolph May. Rebecca Orban.
Here, thank you.
Nick Perillo.
Here.
Oh, great. Dick Pierce.
Here.
Virtual Ross.
Here.
William Shakely.
Here.
And welcome, William. This is your first committee meeting.
Thank you.
Anna Shavers.
Here.
Scott Albright, alternate for Carol Ann Siciliano.
Here.
Lon Smith. Kevin Stack.
Here.
Robert Stone.
Here.
Tom Sussman.
Here.
Steve Harbert. William Vincent. Okay, those were all the names of the committee members who RSVP'd. Are there any committee members whose name I have not called?
I think
Todd.
Alana Cohen.
Hi, Alana.
Hi.
Todd, I had a little trouble with the transmission. This is Lon Smith.
Hi,
I'm here.
Lon. Yep, hi, Lon.
And
Any
this
other?
is Emily Hammond.
Emily, hi, Emily. Okay, Those were all of the committee members. I'm now going to call the names of people who are not on the committee. David Trissel, Virginia Huth, Helen McCoy,
Here.
Christopher Yu,
Here.
Radha Vishnu Vajala,
Here.
Margie O'Haron, Brady Thompson,
Here.
Tim Mullins.
Here.
Great, that is it.
All right. Let me go over reiterate the basic ground rules for discussion. ACUS members have full speaking privilege and are able to unmute themselves. To avoid background noise, though, please keep yourself muted when you're not speaking. And then when you want to speak, either physically raise your hand or add a comment in the chat feature. I'll call on you, and then you can unmute yourself, offer your comments, and then when you're all done, please remute yourself. But also ask ACUS members when possible to use a webcam. Obviously, there are times when you might need to turn it off, but please, as much as reasonably possible, please leave the webcams on so at least I can see you raising your hand when you want to speak. And please note that although we welcome the participation of people who are not ACUS members or alternates, ACUS members are to be given priority in speaking. For members of the public, please use the chat feature to indicate that you'd like to speak. I'll turn to you at an appropriate moment in the meeting, and the person running our GoToMeeting platform will unmute you and then remute you when you're done speaking. For all participants, please use the chat function only to indicate that you'd like to speak, or for committee members to vote when asked. As we all know, after 7 months of being on Zoom and GoToMeeting and everything else, sometimes the chat can become a sort of an alternative discussion, and we want to be sure to keep the discussion in the main discussion. So please don't hold any sidebar discussions or put substantive comments in the chat feature. Only members of the Rulemaking Committee, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsel have a vote. Please do not vote unless you're a member of this committee. The staff council and I have a list of committee members in case you're unsure. All right. So let's move on to the discussion. Matt made a joke when we started about maybe me getting more than I bargained for. Everybody might feel that way. Thinking about today's meeting, it reminded me of the old saying, "I'm sorry I wrote such a long letter. It didn't have the time to write a short one." So much of what we've done over the first 3 meetings and leading up to this meeting have been exercises in subtraction as much as addition. And even the things that we've been adding in have generally been replacing longer substantive comments and recommendations. The great challenge through all of this has been trying to create meaningful and useful and reasonable recommendations for the handling of material, all of which is just defined by complicated, nuanced, and sometimes contested areas of law, all the things that are detailed in Christopher's fine report, and all the agency practices that have arisen over the time to grapple with those things. And in this last meeting, we had 2 main tasks leading up to it. One was a substantial rewrite of the part of the preamble that tried to summarize that background of law without sort of taking substantive positions on it, let alone offering any disagreement with existing law, and then tightening up some of the recommendations. And of course, in the process of doing so, in this time since, I guess our last meeting was in late August, the ACUS team in implementing sort of the new write-up in the preamble and trying to tighten up the recommendations, found several places that needed non-substantive adjustments. Of course, that was the intent. If anybody sees things that go beyond non-substance and really do have made substantive changes to the things that we've agreed on in the past, of course, we want to discuss that, and we want to make sure that the results of this meeting today, our last meeting, really does reflect the culmination of the work of this committee. and hopefully results in recommendations that the committee can stand behind. Matt, is that a fair way of putting this?
Absolutely. Thanks, Adam.
Okay. Well, let's proceed in two parts. First, let's begin with the preamble, which is the can we've so often kicked down the road. And then after we work through that, we will move on to the recommendations. And when we get to the recommendations, Todd will offer just some introductory notes on the changes that maybe require the most attention by his sites. So turning to the preamble.
And let me just first let me just say I'm gonna share my screen now so I can make changes as we go along. For people who have their documents printed out, or they want to pull up their own version of the document, make sure that the date in the footer is November 17th. If it's not that one, then just make sure you pull that one up. So that's all.
Yeah, and on that point, I mean, there's been a few documents transmitted in the last few days, and always in pairs, right? There's the clean version with some comment bubbles, and then the real red line version with all the changes marked. As you can see on the screen, Todd is using the clean version with comments. Of course, I'm sure we'll be referring to both documents along the way. So when you're referring to a document, please try to be clear which one you're referring to. I guess the default assumption is we'll be talking about the clean version with comments, but please try to be precise in which version you're referring to, and I'll try to do the same, and I apologize in advance for the moments when I flubbed that myself. Let's start with the preamble, and a sort of a simpler change at the beginning of page 2 of the clean version with comments. This is a small mark at the top of the page. In the highlighted language, it begins with the term notwithstanding any countervailing benefits. You can see from the carryover from the earlier page, it says the recommendation specifies how agencies should handle protected material, notwithstanding any countervailing benefits of disclosure. As the staff points out, notwithstanding might simply not be the right word here. Obviously, it's trying to capture the idea of agencies handling protected material in light of any countervailing benefits of disclosure. I would just, in light of the staff's suggestion, I would just recommend cutting that last phrase altogether, notwithstanding any countervailing benefits of disclosure. Does anybody have any objections to doing that? Everybody's faces are tiny on the screen, so I'm going to shrink down Todd's page here. Okay, well, without any objection, Todd, let's go ahead and strike that clause. The second part of that highlighted phrase is more substantive, where we've tried to add some introductory definitions of what we're talking about here. Personal information and confidential commercial information. Obviously, this is something we've gone around and around on in the previous meetings. Does anybody have any objections to the way that the current draft phrases this? I don't see any. Okay. Well, without any objections, Todd will go ahead and keep the text as it's that last part as it's drafted, starting with for purposes of this recommendation. Okay. Okay. So the real substance that we've added is obviously from pages 3 to 5. It's marked by a couple of comment bubbles, and we'll get to in the middle a helpful comment from Scott Albright from EPA. But I hope folks have had an opportunity to review pages 3 to 5. This really is the core of what we filled in after the last meeting, trying to summarize very, very swiftly the state of substantive law surrounding all of this. Christopher, I hate to put you on the spot, but since you drafted the report, did I and the ACUS team put anything in there that jumped out at you as either incorrect or just sort of uncharitable?
Not at all. I think it's a very effective proposal.
Well, does anybody else have any thoughts on this? Again, this is something we drafted since the last meeting, so I want to be very careful. Rebecca Orban.
Thank you. And I really appreciate the work that went into this. I think it reads very well and it seems correct to me. I have one comment on line 45 of the clean version, and that comes actually from our FOIA people. I'm not a FOIA expert, but they took a quick look at this this morning and said that they're not comfortable with the word only, and they would prefer something like main or primary, only because they were not able to commit that that was the only exception relevant in this case. Would that be an issue if we sort of softened only?
I think I saw Christopher shake his head no for a second.
Just to make it concrete, I take, Rebecca, your suggestion is to replace the word only with primary. I think that's an excellent suggestion.
Great, thank you.
I saw other heads nodding yes, and I'm certainly amenable to it myself. Anybody have any further thoughts on Rebecca's suggestion? All right, so we will change, Todd will change only to primary. Let me just note, I mean, we'll continue to work through this, but one comment that Scott Albright from the EPA offered to us, it comes in, where is it? Todd, can you reiterate this? I'm trying to see where the comment bubble is pointing. Oh, here it is. It's the opening line on line 58 of page 4 of the clean version with comments. The opening words, we say at the outset, either by law or as a matter of discretion. And Scott, you're on the call. Do you want to sort of elaborate the comment you made to us earlier?
Sure. Yeah, it was pretty straightforward, and you just highlighted it. I paused on the clause as a matter of discretion in regard to the information that's described within the rest of that statement. Just because you know, the way that in my experience we tend to handle personal information and confidential commercial information isn't by discretion. It's you know, it's either exempt under Exemption 6. The Privacy Act or Exemption 4, or it's not. Now, I mean, that might require the balancing test in the FOIA context, or maybe some other analysis, but ultimately it's a result of that analysis that's required by law. But I just wanted to throw that to the group to see if anyone else shared that concern.
Thanks, Scott. So Scott discussed this with us ahead of time, and in our discussions, what I suggested was maybe taking the last sentence of that paragraph, or the last clause of that paragraph, and putting it at the front to really make clear what we're talking about here. The entire point of that introductory phrase, either by law as a matter of discretion, was just an attempt to try to, in shorthand, just reflect the fact that this is governed, you know, mostly by law, but oftentimes there are some zones of discretion that agencies are operating in. And maybe the easiest way to make that point without over making that point is by beginning the paragraph with the words that end, saying, particular cases are governed by specific requirements of law, not broad categorical labels, period, but generally, comma, agencies often consider. And just say that as a way of trying to summarize what's been said without putting any kind of substantive gloss or making any kind of implications regarding the breadth of discretion that's at issue. I hope that made sense. Does anybody, would anybody object to making that change? Okay.
So Adam, I just want, this is Todd.
Yeah, go ahead, Todd.
So the way the sentence would read now, or the way the paragraph would read is the very first sentence of that paragraph is now particular cases, all the red line language right here. And then yes, agents often consider certain types. So essentially this would come out. And then where do we then capture the concept of either by law or as a matter of discretion, or do we not capture that, or do we just eliminate that now?
I think we've made it clear throughout the substance of the preamble that maybe we don't even need to reiterate that point right there. I think we could probably just cut either by law or by discretion in order to avoid any kind of wrong inferences that Scott thought might be drawn from it.
Right. Okay. I mean, if that's fine. So I just want to confirm the language up here is now what the language the committee wants to see in that paragraph.
Let me bring it up here. Yeah, that's how I meant it. Does anybody object to my sort of heavy-handed edits here? Oh, no, okay. All right, so let's stick with that. Does anybody else have any comments on the new preamble language from 3 to 5? Again, I just want to reiterate, we drafted this kind of on the fly after the last meeting, and this is the first chance for people to look at it and comment on it. And I really don't want to just give it the bum's rush. Okay. All right. Well, without any objection, we'll stick with that language then. Thanks, everybody. That brings us then to the recommendations. And as I indicated earlier, I think since, especially in the red line version, there's just a lot there marked in red. Reminds my high school English teacher handed back my papers in waves of red ink. But as Todd pointed out in earlier emails, it's really, and it's here in the comments, it's really intended not to be substantive by and large. And so Todd, could you maybe give just a couple of the highlights of what was intended to be done here, and maybe point us towards the specific changes that might need the most immediate attention?
Sure. So paragraph 1 that's highlighted right here definitely was a major change from the version the committee last saw. And that was made because, well, for 2 reasons. One, to establish the concept of developing written policy. So in the subsequent recommendations, or I'll just call them numbered paragraphs, we discussed what agencies, what written policy should do, to some extent the content of written policies, but we never actually explicitly say that agencies should develop written policy. So that kind of formalizes that, what was previously an implicit assumption. And then the original language also suggested, and this goes back to the point we discussed earlier about either by law as a matter of discretion. The original language was agencies should decide whether to withhold protected, certain types of protected material. In some instances, that outcome may be prescribed by law. It might not be discretionary. So we didn't want to imply that it's always a matter of agency decision. So so therefore we changed the wording of this very substantially to what it is currently.
Okay, maybe we'll stick with that one then to start. Does anybody have any questions or comments about this or objections? Rebecca, please.
Thank you. So I do have concerns about the insertion of the written policies language. And I don't know that I shared the implication that a written policy was part of the subsequent recommendations. I do like the new language about clearly notifying the public, but we enjoy a lot of flexibility in how we notify the public, including language in the preamble to a proposed rule, language on your website. There may not be a single policy document. I think there's some positives to that, and especially given some of the new review and publication requirements we're starting to see on agency guidance, I would be reluctant to say there should be a single policy. It really takes away our ability to tailor the way that we handle information to the audience who's submitting it. So I would prefer to see, if not a reversion to the original language, which was fine, perhaps omitting should develop written policies and just say agencies should describe what kinds of information qualify and should clearly notify the public. Both of those things I agree with, but the written policies piece is hard from us.
For what it's worth, thanks for that, Rebecca. For what it's worth, it seems to me that taking out the words written policies, but just saying should describe, it softens it enough that it does sort of keep the basic recommendation of agencies giving some kind of public explanation of this without using the word policies, which is a sort of a sensitive term, of course. So in light of, does anybody else have any comments on this? In light of, oh, go ahead, Lon, please.
We have 3 definitions here. We have 2 of them in the preamble of personal information and confidential commercial information. Then we have a definition here of protected material. I was wondering, would it make sense to start off under the recommendation with the 3 definitions, repeating the 2 from the that are described in the preamble, and then taking this definition of protected material, which would follow right after those 2, and then just separating them out so that somebody reading the text can always refer back to those definitions and not have to search through the preamble or this description at the beginning of the first recommendation.
Thanks, Lon. Thank you, Lon. Let's close the loop on Rebecca's point first, and then we'll move to Lon's point. Does anybody have any objections pursuant to Rebecca's point of just deleting the words develop written policies that? So it would read, agencies should describe what kinds of personal information? Okay, seeing none, we'll go along with that. Thank you very much, Rebecca. Lon raises a very good point that we're using the definitions from the preamble, but not including them in the recommendations. I have to admit, I'm not sure how ACUS normally handles this when it defines terms in the preamble. So if anybody from the ACUS team has any guidance on this, Reeve, I see you're unmuted. Do you have any thoughts on this?
Yeah, happy to weigh in on that. So yeah, as a general matter, we do try to, ensure that both the preamble and then the numbered paragraphs stand independently so that somebody doesn't have to refer back. So I think Lon's point is well taken. We want to try to do this as concisely as possible, but I think that, adding in some definitions so that this stands on its own, I think would accord with what we've done in past recommendations.
Thanks, Reeve. Well, in light of that and Lon's helpful suggestion, I'll propose this. Could we, Todd, just insert a new paragraph 1 that will just begin with, for purposes of this recommendation, personal information is defined as, and we'll just insert the definition from the preamble, and then confidential commercial information is, and then insert the definition from the preamble. So no substantive change. We're talking about just cut and paste or copy and paste adaptation from the preamble, and then end that by saying this recommendation shall refer to this information collectively as protected material. So that we'll move all the definitions into paragraph 1. I'm sorry to sort of state that on the fly while you're typing. And then we can move right to what's currently recommendation 1 to reduce the risk, et cetera. And we won't even need to include the sort of parenthetical protected material in that one because it will have been taken care of in the first paragraph. I see, I got the A-OK from Dick Pierce, which is always reassuring. Does anybody else have any thoughts on that, or are we okay with that? Okay, thanks, Lon. I appreciate you pointing that out, and we'll clean that up after the fact. But that's, again, there will be no substantive changes. It will just be copying and pasting, parachuting in the definitions from the preamble, and then collectively defining those as protected material before moving on to the old recommendation 1, which is now going to be recommendation 2. Todd, you're still, I just dropped all that on you, but
yeah.
Do you need to, go ahead.
No, I got it, Adam. So I'm going to do, I just don't like editing on the fly because then it just becomes messy. So I've noted that all in the comment bubble here as a note for myself. When I go back to revise this, I'll insert that.
Thanks, Todd. That was the first major change. Todd, do you want to highlight maybe the next one the next change that the team made that sort of deserves a special attention?
Yep. So actually, it would be the next recommendation, but or actually, it's the same recommendation. So paragraph 1, if we go down to E as in Edward, so in the original, it said, where it currently says protected material, it said personal information. We didn't think that there was a reason to limit it to personal information. That is, if somebody requests that a comment may have, someone notifies the agency that a comment may have commercial information, the agency might also want to take the action that's described in E. So we just broadened it here. Didn't think that there was really any reason to limit it to personal information, but we also wanted to make sure that the committee had a chance to specifically look at that, since that is definitely a substantive change.
Thanks, Todd. Does anybody have any objections to broadening that out to protected material? None? Okay. Thanks, Todd. We'll keep that. Before that was a comment reflecting something I had pointed out since the last meeting. Recommendations 1C refers to unique identification numbers, social security numbers, and so on. It just seemed to me that after the last meeting, especially as we tried so hard to reduce any kind of sort of substantive judgments on what is or is not protected, that one struck out as me as something we probably need to look at one last time. I mean, to be honest, those are surely the most sort of the core of protected materials, generally speaking. But in the interest of avoiding commenting on the substance of this stuff, it may be worth revising or deleting that. So I'll just raise that. Does anybody have any thoughts on that, whether that 1C goes too far and ought to be revised or deleted? Does anybody see the value of keeping it in? Please, Lon, go ahead.
Well, I wondered, based on the other changes, if C shouldn't simply say instruct members of the public never to submit protected materials. And if you do that, then D is unnecessary.
Yeah, now, of course, people can submit protected materials and waive their rights. And in the interest of sort of agency discretion, I want to just flag that. Go ahead, Lon.
Well, I mean, I just don't see, of course, and they can waive their rights to personal unique identification numbers too, right? I mean, the comment applies to what's already there.
Yeah, that's a good point. Thanks, Lon. Richard?
Yeah, I think the point of this paragraph, there was people submitting information about third parties, which is kind of a unique point, though. So I think the paragraph does have value in that respect, but I think that I'd agree with limiting it to just talking about protected material, not getting into the specifics. So I would keep protected material and then the reference to third parties.
Yeah, thanks for reminding me of that. That's a good point. Okay, well, in light of those comments, maybe we'll change paragraph C as was just described to say, instruct members of the public never to submit protected materials that pertain to third parties. And then shall we end it there or keep this last part about such as medical information and trade secrets? I would suggest, given what was just said, to keep it simple. Instruct members of the public never to submit protected material that pertain to third parties. Without any objection? Okay. All right. Todd, can we make that change then?
Yep, just did.
Okay. I see in what's old recommendation 2, it'll be recommendation 3 now that it's being edited. It's on page 6 of the clean with comments. An agency should include the written policies and notifications described in paragraph 1. Of course, now we don't have written policies there anymore. So I suppose it should say an agency should include the information described in paragraph 1 or a link to that information in at least the following places. Any objection to that? All right. So Todd, we'll go ahead and make that change as well. All right, Todd, would you like to point us to the next sort of near substantive comment?
Yep, so that's starting in the, I think it's numbered paragraph 6, but the first comment that I have is on the subheading there, recommendations for agencies that screen comments for protected material. All right, so for that one, similar issues we discussed earlier, originally that said for personal information. So we substituted the broader term protected material for personal information. And as with the earlier instance in which we did this, we just felt that there wasn't a need to limit it to personal information. That is, there are agents, even though perhaps there are few agencies that screen for commercial information. And as Christopher's report points out, legally it's never required. Nonetheless, some agencies do it, and for those agencies that do, there'd be no need to exclude the applicability of paragraphs 6 through 8 to those, or actually 6 to 9 to those agencies. So we just thought it made sense to broaden it here, and wanted to get the committee's view on that.
Thanks, Todd. Rebecca?
I'm sorry, I don't want to derail this conversation, but can we put a flag on what was recommendation 3, which also has that written policies language? And if you could get the same edit.
Yep, there will be conforming edits to all places
Perfect.
in which that appears. Yep.
That's all I needed. Thank you.
Oh, thank you so much for pointing that out, Rebecca. On the point that the point that Todd just raised and expanding this out to protected material in general, does anybody object to that? All right, thanks, Todd. In the recommendations that follow that heading, we had helpful comments from Emily Bremer. They're in the comment bubbles, but Emily, would you like to maybe elaborate here the points that you made?
Yeah, so on recommendation 6, it seems like there are sort of 2 caveats in there, and I'm not really clear on whether they're both necessary, and if they are both necessary, what they mean. So we have, we're encouraging agencies to redact protected material if appropriate, and publish the rest of the comment if such material appears infrequently. And so I guess my first question is there some redaction that would be appropriate that doesn't involve material appearing infrequently? And it seems like if appropriate covers the water, but if all we're concerned about, or if the only caveat is about sort of frequency of the information, then can we delete if appropriate and maybe relocate if such material appears infrequently? I just found it confusing that they're both there.
Rebecca?
Thank you. I agree with Emily about the confusion. I don't think that frequency is maybe the right metric there. I spoke to our docket folks about recommendation 7, which is the next one, and they pointed out there are some reasons they can't redact that are simply technological because of the format of the document or things like that. So I think that in both 7 and 6, we might leave it with if appropriate and take out some of the references to how frequent the material occurs, frequently the material occurs.
Thanks, Rebecca. So I guess that would mean in old paragraph 6, just deleting if such material appears infrequently. And then in the following one, old paragraph 7, we would just say if redaction is not feasible, comma, and then continue, I guess, with agencies should consider presenting the data in summarized form here and after aggregation, or Emily, and Rebecca, your comments.
So I also was confused on this one because it seems like there are 2 things happening simultaneously and they're not addressed separately. So, I mean, there's a question of how you convey information that's in a single comment that needs to be redacted if the information can't be redacted. And then there's a question of whether one solution, if you've got a lot of individual comments, all of which have protected material, if you can, keep those comments back and then provide the information in an aggregated form that meets the goals. And it just, those are 2 separate issues and they're blended in paragraph 7 in a way that for me was just confusing.
All right. Yeah, Richard, please.
Okay, I don't want to get us off track, but backing up to 6, I was wondering about that, if appropriate. We're kind of reading that to mean if feasible or something of that nature. I wonder if it might imply to some people that there's reasons, like maybe policy reasons, why you wouldn't want to redact protected material. Is it maybe ambiguous in that sense? I'm not sure if anybody had that in mind.
Adam, I think Rebecca was the one who proposed this language at the last meeting.
That may be, it was a long time ago. But So one of the things we struggle with, I think it's a really interesting question. So for example, if the comment is location specific, for example, I'm with the Coast Guard and we receive comments that say, I swim in this waterway. And so that is not protected, it depends on how they phrase it, but it is kind of their location and combined with their name makes them traceable. But there's a policy reason to keep that in. So just to your point just now, maybe there's sometimes, maybe we mean appropriate and not feasible, but I think mostly we mean feasible.
Mm-hmm. Okay. Yeah, I wonder if it would be for readers, whether there would be, if they'd be uncertain about that, or if we'd want to be more specific about what we mean there.
As always, I got to admit, I do worry that if we put too much meat on the bones there, we're going to be back in the business of substantive judgments, and appropriate. It really sort of begs the question, but also sidesteps the question.
Oh, I'm so sorry.
Go ahead, please.
Sorry, if we just delete, if appropriate, we have agency discretion earlier in the sentence. Does that work?
Mm-hmm. Yeah, actually, that might be clearer. Let's see. So it would just say as a matter of agency discretion. Yeah, I think to me, that would do it.
Okay. That works for me. Does anybody else have any comments on this? Again, the proposal will be to delete if appropriate, and then at the end of that sentence, if such material appears infrequently. Okay, let's start with that and get back to thanks everybody, and let's get back to this bigger point that Emily raises about unpacking two lines of recommendation here, one having to do with material and individual comments, and one having to do with the high frequency, the aggregation of comments. Christopher, not to put you on the spot, but do you have any thoughts on this?
So it's my read is that it's sort of trying to set up a hierarchy of alternatives, which is preference 1 is redaction. 7 says if redaction is not possible, go to aggregation. And 8 says if aggregation is not possible, withhold and make public notice of that fact. And so if that is, I think, is my understanding of the structure. And if I would say that if Emily was confused by it, we should try to make sure that's clear, if that is the understanding of the committee. And if one committee member finds the way it's currently articulated to be confusing, we should clarify. But most importantly, I guess before we clarify it, we should make sure that the committee signs off on the basic approach of this hierarchy of full publication, redaction, aggregation, withholding.
Well, that's a very helpful way to put it. Thank you. And let's proceed with that then, because I think that makes a lot of sense of this, and it might point a way to just tinkering a bit with the wording in a way that maintains it. Does everybody agree with Christopher's basic point about this hierarchy? Redaction, aggregation, and summarization. What was it again, Christopher? Redaction, aggregation,
then withholding, which is number 8.
Withholding.
And
so I just want to say, I want to add to that I think old paragraph 7 in the clean version with comments, getting back to Emily's point, it combines the concepts of summarization and aggregation, which overlap in ways, but they are different. You can have a single document that then, because it can't be redacted, could be summarized. You could have multiple submissions that can be summarized in the aggregate. And so maybe in pursuing Christopher's structure, but also disaggregating, so to speak, the concepts of summarization and aggregation might help. And so eventually, I mean, whether now or eventually, I'm going to propose changing paragraph 7 to say agencies should consider presenting the data in summarized form or in the aggregation of multiple comments. But before we get to that, let's just, again, is everybody on board with Christopher's basic understanding of this as a hierarchy of redaction, and then summarization or aggregation, and then withholding? Okay, let's work within that framework then. Getting back to my point just a second ago, trying to reframe old paragraph 7 to say agencies should consider presenting the data in a summarized form,
Adam,
or,
can I make
please
a
go ahead.
summarized or aggregated form? We'll just use it. I think to accomplish the same thing in 2 words.
Short and sweet. I like it. Can we go with that then? A summarized or aggregated form. And I assume we're taking out the parenthetical here and after aggregation, right? We're going to make these changes throughout. Lon, please. Go ahead, Lon.
Could you explain again the difference? Could you explain the difference between aggregation and summarized form?
Okay, so again, if we're conceiving of old recommendation 7 as not focusing exclusively on the issue of high frequency, right? It's just feasibility in general. If redaction is not feasible, agency should consider presenting the data in a summarized form, which is just, I mean by I guess a single document, we're referring to like a single comment that was filed, summarizing that information, or in the aggregation, which I take to mean multiple comments that are being summarized jointly. Emily?
So I'm also trying to understand and read this as if I know nothing about the project, because I'm trying to, I think the way people read this when they're not familiar with the project and haven't read the report is going to be different than those who are really deeply familiar with the point of the recommendation. One way to make it clearer, because I think what you've suggested makes sense to me as identifying 2 possibilities that are actually designed to address 2 distinct issues, right? There's the issue of, well, we can't redact individual comments, and if there's only one, we can just summarize the non-protected information and release it. But if there's a bunch of individual comments and we can't redact them, then we can aggregate the data to convey the non-protected component. One way to do that more clearly, instead of just saying summarized or aggregated, which again is sort of mysterious if you haven't identified that there are 2 separate potential problems, would be to have a subparagraph A and a subparagraph B, right? So like if redaction of individual, of protected information in individual comments is not possible, agencies should consider one, if it's a single comment summarizing the non-protected information, and then I guess it would be A and B, and then B, if it's, if there's multiple comments aggregating the non-protected information.
Before we go to Christopher on that, I cut Lon off earlier. I'm sorry about that, Lon.
You're talking about aggregating and summarizing comments, but the sentence talks about aggregating or summarizing data. Do you really mean comments there then?
No, I'm talking about summarizing or aggregating data. I'm sorry. I'm talking about aggregating data that's been presented through multiple comments. That's what I mean to be talking about. Lon?
Again, this may just be me, and I'll pass on it. I don't see the difference. When you're talking about data, I don't see the difference between aggregation and summarization of them. But let's move on. I'll go with what you're doing.
Christopher?
So as someone who uses data, and think census, or I see this in a lot of agencies. So if you get, for example, financial data, like earnings data, and there's only 3 companies that are in that category, agencies generally won't report it. Certainly if it's one company, they won't do it. And there's a number threshold where if it's below that, they will actually not report that subcategory. Or if you're reporting data about someone that's in a zip code, and you realize that there's too few people that satisfy that description or the category you're breaking out in that zip code, you aggregate it to a larger cluster of zip codes or something like that. And that's what is one thing is there's threshold. It's a term of art for the use of data, but when the category is too small that it permits inferences about who actual individuals are, you do not report it at that level of aggregation. You report it in a larger number, a larger grouping, so that it's impossible or more difficult to identify what is individually attributable to a person. Now, this may be, and the ambiguity about, I'm going to say what my understanding of the word summary was, which was needs to reflect what the interest of the committee is. And I think if there's any ambiguity about this, then it needs to be, then I think Emily's point is very well taken, because it obviously is. A summary to me is a verbal description of information contained in one or perhaps even more comments. If they're all identical, it's not like you have to go verbatim and say comment 1 said this, essentially the same thing. I think a summary could span more than one comment, but it's not the kind of inclusion of larger categories to protect the confidentiality of the individual, more so than it is an attempt to bring together larger groupings that you can represent in a single way that doesn't disclose the information at question. You know, thinking, for example, about Rebecca's comments about people who swim in a certain area, there's ways you could possibly do that through summaries, or finding ways, you know, to talk about them as uses as opposed to actually swimming, to obscure the specific uses of that. That wouldn't really, in my mind, be fairly characterized as aggregation, because you're not really moving it to a higher level of number of comments to obscure the individual comments, but more a way to recharacterize it, to remove the personally identifying information.
Okay, thanks, Christopher. In light of all that, let me try this, and sort of in the spirit of Emily's breaking it into multiple paragraphs. Old paragraph 7 begins with reference to within a comment, right? If redaction is not feasible within a comment, maybe we start with that and say, if redaction is not feasible within a comment, agencies should consider presenting the information in a summarized form. And then next, and we can give it its own paragraph, it doesn't have to be a subparagraph, we could say something along the lines of, and what I'm about to say is I'm trying to say, if multiple comments submit similar data that presents similar redaction problems, agencies should consider presenting that in an aggregated form, and then with the caveats that follow at the end of that paragraph about data science and so on. That's what I'm grasping for, and I hate to sort of draft it on the fly, but I guess as a first shot, I would try this, Todd.
For what it's worth, I like that. That breaks out the solutions and the problems and matches them up in a way that I think is much, much clearer.
Thanks, Emily. Thank you. Well, let's try it then. Just shooting from the hip, Todd. We'll say, and this is all subject to people kicking it around, but if multiple submissions contain data that raises similar redaction concerns, agency should consider presenting the data in summarized form. I'm not sure whether that actually looks the way I mean it to look, but
you almost
I'm sure it does.
What Todd had proposed, actually, so I think it's
okay.
But that should be aggregated form, correct?
Yes, in aggregated form. I'm not sure whether raises similar redaction concerns is the right way to put it. That was just sort of my first bid.
Todd's original phrasing there was data that presents similar redaction concerns.
Oh.
And I'm
Todd,
to me,
let's stick with Todd. Well, yeah, Todd said it first and said it best.
And I hate to be a stickler. Data is technically plural, so it should be data that presents similar redaction concerns.
True. All right.
Can I ask a question here?
Please, Todd.
I don't know what redaction concerns means, and I guarantee you there'll be many ACUS members who look at that phrase and will be scratching their head as to what redaction concerns means. Can we like flesh out that concept a little bit just so we can put it in plain language?
So may I suggest replacing similar redaction concerns with protected information or protected material, whatever is the word, protected material?
Yeah, that's right. Protected material. Well, I think protected material for which redaction is not feasible. Because I'm trying to mirror what's in paragraph 7.
And I would change present to include then.
Okay. I saw a hand up a second ago, and then Miriam?
Yeah, so maybe to, again, mirror what we had in the first paragraph. So if redaction is not feasible across multiple comments, then
Todd, I think
agency
she's proposing
should
that to
consider-
new paragraph 8.
Oh, sorry, Miriam, could you finish what you're saying?
Yeah, so instead of trying to say what a redaction issue is,
Mm-hmm.
I mean, if in 7 we say if redaction is not feasible, agencies should consider presenting the data in a summarized form.
Mm-hmm.
Then in the next paragraph, we say if redaction is not feasible across multiple related comments or multiple similar comments, agencies should consider presenting the related data in an aggregate form.
I like that. My only sort of friendly amendment to that would be just saying presenting related data instead of the related data, so it doesn't, we're not presuming that there is related data, right? Christopher, Christopher, you're about to say something. What were your thoughts on that?
Never mind. It's all done.
Okay, if redaction is not feasible across multiple similar comments, agencies should consider presenting related data, the related data, any related data, maybe any related data in an aggregated, in an aggregated form. Bertrand?
Is there a distinction that we mean to draw between paragraph 7's reference to information versus paragraph 8's reference to data?
Yeah, that you point that out. That was in that unexplained difference was intended by me, right? I'm not sure how we can, if we're talking about aggregation simply as a matter of crunching numbers, it seems a more specific task than summarizing information, which could be quantitative or non-quantitative information.
Okay.
And so I really do see section 7. We are just talking about aggregation and averages and not descriptions and so on.
Okay.
So it's intended to be a distinction, only because I took this aggregation task to be sort of uniquely quantitative, and the prior paragraph to be broader than that.
Okay, thank you.
At the risk of muddying it, Adam, I would actually change the word data in 8 to information and go against the idea that 8 would only apply to numerical data. There can be status information about it that's actually not numerical, like all these actors have a certain characteristic. If there's only 3 of them, it would conceivably require things that would be not necessarily merely quantitative. And I'm thinking about the survey we did. We aggregated a lot of information about agency responses that were not quantitative. We characterized them as falling into a particular bucket. So I would resist that particular idea.
That's a good point, and I'm convinced. But Christopher, what about the sort of the following sentence in that paragraph, where we talk specifically about data science and disaggregating data? Should that be broadened as well?
Yeah, I would think so.
Do you have any suggestions on how to phrase that?
I would leave the word data science because that's a term of art. Relevant disciplines to ensure that aggregation is thorough enough to prevent someone from disaggregating the information, i.e. relinking the, so I would just make that information, and I think the IE is fine. Because that's just an example. Because data is a subset of information. I think that, that's fine. Either change it or not, I'd be fine either way.
Could we just dispense with the parenthetical altogether and just say from disaggregating the information?
It's fine with me. I think that works.
I'd propose that then, just to keep it simple. All right. Thanks everybody for all of this. Let's take one more look at this. If I'm bringing it up on my own screen, bear with me. If redaction is not, if redaction is not feasible across multiple similar comments, agency should consider presenting any related information in an aggregated form. I like that that language, Todd. You can, I take back my original suggestion. I like this new one much better. If redaction is not feasible across multiple similar comments, agency should consider presenting any related information in an aggregated form. Agency should work with data science experts and others in relevant disciplines to ensure that aggregation is thorough enough to prevent someone from disaggregating the information. Okay. Would anybody object to that or have any further comments? I like it.
I know
right.
Todd deleted
go ahead.
originally question 7 about single comments. Is that a deliberate choice?
Oh, no, that we did want to keep that paragraph in. Todd, this was the first one that I added. If redaction is not feasible within a comment, agency should consider presenting the data in a summarized form. Thanks, Christopher, for catching that. And then a new paragraph. Yes.
Okay, got it.
Thanks, Christopher. Thanks everyone for all of that. Without any objection, we'll move on. We'll declare victory and move on to the next one. Todd, what's the next comment that we want to focus on?
Yeah, so actually it's the next numbered paragraph, which begins, if redaction and aggregation would still permit a member of the public, that paragraph. So here we had a comment from Andy Simons, who points out that when we say agencies should include these descriptions within the preambles, the pertinent final rules, that might be too restrictive. Agencies might not want to put them within the preambles. They might want to put them in other materials, such as response to comments to final rules. So this would just expand that phrase. Instead of within the preambles, it would read within the preambles to pertinent final rules or response to comments to final rules.
Todd, I just want to say right off the bat, the beginning of that paragraph, given what we just did, I think it should now read, if redaction, summarization, or aggregation would still permit. So sort of inserting the summarization term in there. I'm not sure whether good grammar would suggest or aggregation or and aggregation. I think it's or aggregation. Okay, but now to the point that Andy, somebody say something?
Yeah, you could
ahead,
also,
Emily.
at the beginning of paragraph 9, say if the approaches identified in paragraph 6, 7, and 8 would still allow.
That's true. That's fine with me. I think that's a good point. If the approach, could you say it one more time, Emily? The approach identified in paragraph 6 through 8.
If the approach is identified in paragraph 6, 7, and 8, or 6 through 8, and then you don't have to pick between and or.
Okay. Thanks. I got a thumbs up from Christopher, so we'll stick with that. Thanks, Emily. Absent any objections. Okay. Back to Andy Simon's helpful comment. Again, just the point that oftentimes these sorts of information would not necessarily be included in the final rulemakings, in the final rulemaking, the final rule itself, but rather in the sort of supplemental documents that accompany a final rule. I thought that was a good point. Kevin, please.
I wonder a little bit, I'm not sure I object, but it seems like it could be quite distracting to be, I mean, there are certain instances where I could imagine it would be appropriate for an agency to talk about this redaction in the context of its preamble to a final rule, but it could also laden the, if they ended up, it seems in some sense it could be distracting to have those as a sort of sidebar or part of the description. I wonder whether, is this open enough? Because I actually think that maybe the most appropriate place oftentimes will not be in the preamble to a final rule. It will be some, I'm not exactly sure where else in the docket is, but it seems like it would be pretty distracting to have to, for an agency across the board, when anytime you do this serious redaction, to make these comments. So the addition I like, but is it open enough? Or in response to comments to final rules, where is that going to appear?
Yeah. Or in response to comments to final rules. I mean, so Kevin, are you seeing we should sort of give examples of this?
I just wonder, do we really want to recommend that agencies every time they make this kind of redaction have to, in the preamble to the final rule, which is pretty sacred space, comment on this redaction, which is really a kind of sidebar concern?
Right. So I think the thrust of your comment is it would suffice to say, just say in the preceding sentence, when doing so, they should describe the withheld material for the public in as much as detail as possible without compromising its confidentiality. And then just moving on to, agencies should also include on the parts of their websites that describe the rulemaking process. Now then follows a reference to general policy, which we need to tighten up given the earlier comments. But Kevin, would that do the job for you?
It does, yeah.
Todd, Christopher, anybody else have any thoughts on deleting that reference to the preambles and just sort of leaving it totally open-ended? Do we need to say anything in that sentence? When doing so, they should describe, do we need to have any kind of temporal phrase like describe upon finalization of the rule withheld? I mean, do we need that, or Kevin, or do you think we can just leave that out and just leave it as is?
I don't think we need the temporal frame. I mean, presumably they should do it relatively promptly, but I like your deletion.
Okay. Well, let's delete that suggestion, and thanks, Todd. When doing so, they should describe the withheld material for the public in as much detail without compromising its confidentiality. Agencies should also include on the parts of their websites that describe their rulemaking process. Todd, what do we do here? We've already said, based on Rebecca's point earlier, that we want to steer clear of the word policies.
Well, I don't think that change. I don't think that applies here because it says if any.
Oh, that's true. Rebecca?
Yeah, I agree with Todd. Sorry, I agree with Todd. I don't have any concern. I don't have that concern with that language about general policy, if any. That's fine. But I do wonder what work this sentence is doing here. We go from a very specific case where you could not make any part of the public comment actually public, and then now you're on your website describing your rulemaking processes about how you do redaction. This may be a separate thought that that is already covered earlier when we said there should be a clear statement about what it is that we're going to share and what we're going to redact. But I'm not sure it belongs here.
I mean, I suppose in some ways it is redundant of just our general description and our general point in old recommendation 1 about informing the public. Christopher?
Two obvious solutions. Break that into a separate paragraph because it's separate from the substance. It says procedurally, separate from the actual steps, and says disclose it, or rely on the previous statement to disclose all your policies. I think either is a perfectly good response.
You mean the earlier statement from old paragraph 1?
Yeah. So you either could break this in at the word agencies should also include. You could make that a new paragraph 10, or you could delete it. I think either one would respond to the concerns Rebecca's doing. That there's separate considerations about whether it's one says what you 6, 7, 8, 9 say what you should do. 10 says provide notice about what you're going to do. And given that we already say in 1 you should do it. You should provide notice of everything. You could delete this unless you believe that this bears emphasis enough to have a separate paragraph. And that's a decision for the committee.
Yeah. Thanks, Christopher. Looking back at old paragraph 1, I see we don't actually say websites. We just say inform the public. 10 years from now, maybe people won't be using websites anyway. It'll all be on TikTok. But I don't know. Todd, do you have any thoughts on this?
I think I don't. It's really a very substantive question that has to go to the committee because it is a new thing. It's not completely repetitive of what we say above. We do say, include on their websites these things. So I think that just is a call the committee has to make.
Okay. Okay, let's propose this because Rebecca's right. It's substantive and it's a little, and as Christopher also pointed out, it's of a different kind than the rest of this recommendation. What if we just go back to the old paragraph 1 and say, where we say inform the public. Well, when we say, I guess the information we changed earlier, agencies should describe what kinds of personal information, confidential information, should clearly notify the public. I mean, we could just slide in there a reference to on websites and in other we could just say.
Actually, Adam, come to think of it, I think it is already covered because we do say, I mean, unless there's some aspect of it that that we say down there that's not here, it says agency should include the information described in paragraph 1. So that, or a link to that information, at least the following places. Then it says on the part of the agency's website. So I think it's repetitive of this. There might be a small aspect of that below recommendation that's not captured up here, but I think it's like 95% repetitive, but I don't want to say that.
I think it is redundant, and I would just recommend just deleting it from the subsequent paragraph, from paragraph original paragraph 8. I don't see what the numbering is now that we've made edits, but yeah, I would just delete that entire paragraph. That's my suggestion. Would anybody object to that? Okay. Thank you very much, Rebecca, for pointing that out. And thanks, Christopher. Okay. The next comment, right, Todd, is Andy Simon's second comment. It's at the bottom of page 11 of the draft we started with. In the paragraph that begins, such agencies should adopt policies. Andy Simon says we should change should include to should consider including. I certainly don't have any objection to that. Anybody else? No? Okay. Thanks to Andy in absentia. We've covered a lot of ground from the preamble through this, and I just want to make sure that we haven't overlooked anything that wasn't
we did,
in
Adam.
need of conversation.
We missed
Go ahead, Todd.
one thing right here, that the comment right above that, which says note for the committee. So this is also a pretty substantial change. The language originally read, agency should consider preparing explanatory staff or technical reports and should publish these reports on their website. So we got rid of that because the phrase explanatory staff or technical reports are not at all obvious on their face. And rather than take up extra ink to both write those words down and then to explain what they mean, it seemed like the whole idea of disclosing what you have, disclosing the general nature of what you've withheld is already captured by paragraph 1 and other places in the recommendation. So we just felt it was not needed, but that was a substantial deletion.
Thanks for flagging that, Todd. Does anybody have any objections to deleting that from the old version? Okay, seeing none, we'll stick with that then. Thanks, Todd. All right. Does anybody, in racing through all this, have we left behind any points that anybody wanted to raise? All right. Rebecca, please.
I apologize. This is late. I received an email from a colleague who was just reading this morning and asked if we might, up at line 15, add a consider. And I just put that out to the committee to think about. But where it says that it specifies how agencies should handle protected material. He would prefer to see specifies how what did he say? Sorry. How agencies should consider handling protected material. So I thought I'd put that forward and see what people thought.
That's similar to a change we made just a moment ago for Andy Simons. I don't have any objection to that. Anybody? Better late than never. Thanks, Rebecca. Okay. All right. So we've now gone through all this. I'm kind of surprised we've made it to the end of the road. Todd, what do we do next? Is this now where we vote on the recommendation as a whole?
That is your call, but I believe at this point we've been through every change that we've made, and if you would like to call a vote, I think we could do that.
Thanks. Matt, Reeve, Sean, before we move on to this, am I missing anything?
I don't believe so,
No.
All right. Okay.
Excuse me, gentlemen, if I could just say one quick thing. I messaged Todd briefly, and I apologize if I missed this, but did we replace some of that language relating to agency records, preservation obligations that we had discussed?
Yes, we did, and that you can see that it's with the Portland Cement citation on paragraph 7. So if you want to, that's a good point. So if you, I've highlighted, I don't know if you can read the screen, but I've highlighted that language here.
Yep.
Just to clarify this, thanks, Scott. What Todd's referring to is just what he and Andy had pointed out was, the taking care to avoid suggesting that anything that we're talking about here, redactions and so on, is an open door to destroying records that are by law required to be retained. And of course, that's not what we mean. And so Todd added a sentence to that effect. Okay. All right. Well, I think we've brought the conclusion to a head, and so we will move now to vote on the recommendation overall, the preamble and the recommendations as a whole, as have been edited now through today's discussion. Okay. On taking a vote, as I've already noted, only members of the committee have voting privileges. We have the list of committee members, and so if anybody is in doubt about their status, please just let us know. I'm going to do this by a show of hands. We'll start with the yes and the affirmative in favor of this document, and then we'll take any no's. Before I proceed to a vote, any questions or anything? Okay. So we'll have a show of hands, all in favor of adopting the recommendation as it now appears. All right. Any opposed? Okay. Not seeing any. I guess we'll take it as passed in the affirmative. Thanks, everybody.
Can I ask a quick question?
Yeah, please.
Sorry,
I didn't see who said that though.
This is Jenny Jones. Will you be circulating the updated document today?
Todd?
Or sometime? I guess
Yeah.
what's the timing?
Yeah, so I guess what happens next is that there have been a number of, there's a number of stylistic edits that have to be made due to the changes from today. I also have to make some of those changes that I put in the comment bubble. So the committee will see this recommendation again before the plenary.
Okay.
But at that point, there won't be any suggested changes that you have will be considered on the floor of the assembly during the plenary session.
Got it. Thanks.
Unless anybody has any stylistic suggestions for the committee on style before then.
Vegas team, any sort of final words before we adjourn? Oh, all right. Well, on that note then, thanks everybody for all your hard work over the last several months, and thanks especially to Christopher for the fine report that gave rise to all of this. Much appreciated. Happy Thanksgiving, everybody. We'll see you at the plenary, but in the meantime, this meeting is adjourned.
Thank you, Adam.
Thank you.
Thank you.
Thank you.
Thank you.
Thanks.
Thank you.